Welcome to my channel, Legal Jargon. In my channel, I would be discussing law-related concepts and other current affairs updates relevant for cracking judicial services exams and other competitive exams. Please like and subscribe my channel for further updates. In this session, I would be covering the topic of confessions given under Section 164 of the Code of Criminal Procedure. Confessions are to be recorded before a magistrate under Section 164 of CRPC. Section 164 of CRPC lays down a special procedure regarding recording of confessional statements. It has to be made during the course of investigation before a competent judicial magistrate. There must not be any pressure or influence while recording of the confession, and it has to be made voluntarily or freely. It can be used as substantive evidence. The court will presume the genuineness of the record of confessions and the circumstances under which it is made as true under Section 8 of the Indian Evidence Act. Section 164 of CRPC does not override Section 29 of the Indian Evidence Act. Section 29 of the Indian Evidence Act deals with confessional statements that otherwise are relevant, do not become irrelevant because of the fact that they are made under a promise of secrecy or under the influence of alcohol, or deception has been practiced upon the accused person. The ingredients of Section 164, subsection 1 CRPC are as follows. It can be only recorded by a metropolitan magistrate or a judicial magistrate. No police officer can record a confession, and if a confession statement is made before a police officer, it will be barred by Section 25 and Section 26 of the Indian Evidence Act and cannot be used as substantive evidence. If an executive magistrate or any other magistrate is not empowered to record a confession under this section, then such a confession cannot be put in evidence, or no oral evidence can be allowed to prove such a confession. This was stated in the case of State of UP versus Singara Singh. A confession statement can be recorded during the course of investigation at any time before the commencement of inquiry or trial. It is very important here to remember that the confession can be only recorded before the commencement of inquiry or trial. Section 164, subsection 2. Before recording of a confession, the magistrate has to explain to the person making the confession that he is not bound to make it, and it can be used as evidence against him. The magistrate has to disclose his own identity to the accused person and tell him that he is no longer in the hands of the police. The confession has to be recorded in a memorandum made by the magistrate. The magistrate cannot record the confession unless he is of the opinion that the confession is being made voluntarily. When a person appears but is not willing to make a confession or declines to make a confession before the magistrate, then the magistrate will not authorize the detention of the person in police custody, but send such a person to judicial lockup. This is given under Section 164, subsection 3 CRPC. The recording of confession has to take place in the manner provided under Section 281 of CRPC. Section 281 of CRPC basically lays down the form of recording of confession by the magistrate. It has to be recorded in a memorandum which has to be signed by both the magistrate as well as the accused person, and the magistrate has to certify that a true account of statements have been made by the accused. The recording of the confession has to take place either in the language of the court or in the language which the accused is comfortable with. The magistrate has to record the confession in open court during court hours. This was stated in the case of Hemraj versus State of Ajmer. If the magistrate records a confession outside the premises of the court and not in court hours, then it will amount to extrajudicial confession. The magistrate has to follow certain precautions and steps before recording of the confession of the accused person. He must give adequate time to think and reflect upon before the accused can make his confessional statement before the magistrate. When the accused person is coming from police custody, an interval of a day's time or 24 hours has to be given to the accused person by putting him in judicial custody. After the accused has freed his mind from any police influence, he can give his confessional statement before the magistrate. An inquiry has to be conducted by the magistrate as to any treatment or any external influence by the police upon the accused. Inquiry as to what type of treatment was meted out to the accused person while in police custody, and whether he's received any marks or injuries while in police custody. The magistrate has to also order the removal of handcuffs by the police before recording of the confessional statement in order to free the atmosphere. Then the magistrate has to state to the accused person that he is protected from any torture from the police if he declines to make a confessional statement, and he will be sent to judicial lockup even if he declines to make a confessional statement. The magistrate must ascertain whether a statement is made voluntarily or not, and in order to do so, he can put some questions to the accused. There is a test to determine the voluntariness of the statement. The first part of this test is to put questions to the accused and see whether he is mentally fit to understand the warnings and fatal statements of the magistrate before recording of the confessions. If the magistrate finds out that the accused person is mentally disabled to understand the warnings and the questions put forth by the magistrate, then the magistrate can declare his statements as of involuntary nature. The second part of the test is to, by oral or documentary evidence, understand the real motive behind making of the confession. If there is a strong motive behind making of the confession, then the magistrate will treat the nature of the statements made by the accused person as to be voluntary. The magistrate has to explain to the accused his constitutional rights under Article 22, subsection 1 and section 303 of CRPC, under which he has a right to consult a lawyer of his choice. The accused has a right to take free legal aid in the case of him being a pauper. This also has to be explained to the accused by the magistrate before he can make a confession. The confession has to be recorded in the manner provided under section 281 of CRPC. The manner provided under section 281 of CRPC, the form and memorandum, has already been discussed previously in this session. As already discussed earlier, the accused has to be explained of the fact that he need not make the confession and he is not bound by it, and it can be used as evidence against him. The accused has to be sent to judicial custody upon making of the confession or once his confession has been recorded. The recording of the confession has to take place in the language of the accused or in the language of the court. The manner of recording the confession has to be done in question-answer format. The record of the confession has to be read and explained to the accused in the manner which he understands or in the language in which he understands. It has to be further signed by the accused person, and the magistrate has to attach a memorandum at the foot of the record. It has to be recorded in open court during court hours and upon oath being administered by the magistrate. The magistrate who has recorded the confession has to send the record to the magistrate who inquires the matter when required by him. The magistrate does not explain to the accused that the that he is not bound to make the confessional statement and it can be used against him. If such a warning, if not given to the accused person, will not make the confessional statement inadmissible as evidence. Non-compliance with section 164 subsection 3 is not fatal. It can be regularized by the application of section 463 of CRPC. Section 463 CRPC allows oral evidence to be given to prove the procedure followed under section 164 CRPC. But however, it does not allow a subdivisional magistrate without having jurisdiction to record a statement, a confessional statement under section 164. Such a statement cannot be regularized under Section 463 CRPC. The court shall outrightly reject a confession if it is not made voluntarily.